Welcome to Our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law Section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hi, welcome to Our Curious Amalgam, the podcast from the American Bar Association Antitrust Law Section. My name is John Roberti.
And I'm Christina Ma. Today, we are kicking off a special 3-part fireside series with the staff of Our Curious Amalgam. In these episodes, and with the help of the Antitrust Law Section committee members, we examine the biggest highlights of the year across antitrust, consumer protection, and privacy law, and preview what is to come in 2021. Sergei Zaslavsky is our producer for this series. Hey, Sergei.
Hi, Christina.
So what do we have today?
So today we're going to kick it off with summaries from 3 different committees. We're going to hear from Paul Wang and Drew Welling of the M&A Committee. We're going to hear from Eddie Hasdu and Kelly Fain of the Economics Committee. And finally, we're going to have Debbie Salzberger speaking on behalf of the Insurance and Financial Services Committee. And to help make sense of it all, we're also very lucky to welcome a few of our regular hosts. In addition to John and Christina and me, we're going to have on today Anora Wang, Alicia Downey, and Tammy Zhu. So I think with that, let's dive right in and let's turn it over to the M&A Committee.
Hi, everyone. I'm Paul on the M&A Committee, and I'm here with Drew Welling. We thought we'd give you an update on the comings and goings in M&A this year and what to look forward to in the coming year. So without further ado, let's dive in. Drew, what's been the most significant U.S. merger challenge in the past year, in your opinion?
Hey, Paul, I'm glad you asked that. I've been thinking about this, and I really have to say that it's the DOJ's challenge in Sabre Fairlogic, Sabre's proposed acquisition of Fairlogics. Just by way of background, Sabre operates what's called a global distribution system, or GDS. And essentially what that is a computer network that connects airlines and travel agents to sell airline tickets. So it connects with airlines to see what prices seats are being offered at and availability, and it connects travel agents and tells them what the availability and the prices are and facilitates transactions. Sabre proposed to buy Fairlogic, which did something similar, but only connected on the airline side of the network. So basically, it looked at availability and prices on airlines. Sabre proposed to purchase Fairlogics, and the DOJ challenged the transaction. Now, what's interesting is that the defendants in this case, Sabre and Fairlogic, actually defeated the challenge in United States District Court. But what's really interesting is the reasons why. The district court judge in that case held that as a matter of law, Sabre and Fairlogics did not compete in the same market. And the judge's reasoning was based on the Supreme Court's decision in American Express, which held that two-sided transaction platforms, as a matter of law, can only compete with other two-sided transaction platforms. That case, Amex, was a Section 1 case. And what was unique about Sabre Fairlogic, among many other things, is that the Amex decision was applied in the merger context for a Section 7 challenge. The judge found that because Fairlogics only operated on one side of the market that Sabre did, that they could not compete with each other, and the DOJ failed to prove its case. More interesting is that the CMA, the Competition and Markets Authority in the UK, also challenged the transaction. And a few days after the decision, following the bench trial in the US district courts, the CMA blocked the deal, finding that there would be a reduction in competition on the one side of the market where the two parties competed. So there was a divergence in the analysis, which was pretty unique. But taking it even a step further, what was really interesting as well was that after the CMA's decision, the parties abandoned the deal. And so the Department of Justice moved to vacate in the Third Circuit. The vacator was successful, and as a result, the district court's opinion in the U.S. has been vacated. So there is no precedent, but it may be that a roadmap has been set out in a line of argument to defend merger challenges in two-sided markets based on Amex.
Well, it's a good summary from Drew and a very interesting case. And one interesting thing about it, the basis for the Delaware District Court decision, the idea that two-sided transaction platforms cannot compete with one-sided businesses, has been quite controversial. The recent House report on competition and digital markets even recommends a legislative override to clarify that one-sided businesses can compete with two-sided platforms. So definitely an interesting issue to watch. Now, Tammy, do you think there are other aspects of the decision besides the holding that two-sided transaction platforms cannot compete with one-sided businesses that will prove to be influential?
Yeah, I mean, beyond the two-sided platform ruling, the court also picked apart the relevant product market, which the DOJ proposed was booking services. The court pointed out that one, booking services was a term that the witnesses hadn't really heard of or used. Two, booking services was not really a standalone product that either of the parties were selling. Three, the DOJ's expert couldn't even put a value or price on these services. The court listed a slew of other reasons, but I want to point out those three because I think that those will come up again as regulators challenge deals involving nascent competitors, because nascent competitors are often shifting and expanding and changing the contours of existing established markets. I do want to note also that I think the two-sided platform holding will be revisited and relitigated in court because two-sided platforms are ripe for disruption and in particular for disintermediation, which is a threat that a newer technology will replace or reduce the need for that intermediary. And we're seeing more startups every day building technology to reduce reliance on expensive intermediaries. Finally, just to touch on one point that Paul and Drew pointed out, which is that the district court decision is now vacated. While the Third Circuit did vacate the district court's order, the Third Circuit specifically noted that they're expressing no opinion on the merits of the party's dispute before the district court. And the Third Circuit's order should not be construed as detracting from the persuasive force of the district court's decision. So future courts can still look to that vacated district court order as persuasive authority.
So, John, do you have anything to add as well?
Yes, and not really directly on that point, Sergei, but going back to the question that was directly asked, which is what do we think about the merger challenges? One of the things I think is important this year, and again, looking forward, is there are a lot of them. The DOJ, there are a number of challenges that are out there. There was a period of time years ago where you wouldn't see merger challenges going on for years. There are multiple merger challenges going on now. And I can't think, we'll see what happens, but I can't think 2021 you're going to see any slowdown there. So watch this space. It's an interesting time to be litigating mergers.
Absolutely. Well, let's go back to Paul and Drew to see what else they had to say about merger enforcement in 2020.
So Paul, turning to you, there has been a lot of enforcement activity in the tech space over the past year. And I think it seems fair to say that we should expect increased scrutiny of technology transactions looking forward to the next year. But as an economist, what do you see as the key antitrust issues in tech going forward?
Thanks, Drew. That's a good question. First, I'd say maybe not tech per se, but what I'll call global economy mergers. So I think there's greater and greater attention on fast-moving sectors with innovation, and sectors where the boundaries might be blurred between geographies or between products in a way that makes them harder to deal with. And so, yes, I think economists and practitioners are sitting down and saying, what are the economic tools we can use? And do the tools that are adapted to primarily look at price effects or primarily think about widgets, if you will, do those work here? And certainly there's a host of new questions. Just to name a few, market definition, as you just talked about, Drew, clearly an important question when we get into the tech sector, and again, these global economy mergers. Nascent competitors, obviously a hot topic given the activity in the last week. Free products. What do you do about zero price products? Also, what do you do about innovation? What do we even mean by innovation? The list goes on, but again, I think the point being, there's going to be a lot of thinking on economic tools and how they're applied when we move out of kind of the traditional box of price effects and kind of simple, basic products.
Interesting stuff. And I think the emphasis on economic tools is spot on. I think many observers pitch the kind of key philosophical battle in antitrust today as should antitrust focus on price effects or should antitrust focus more broadly on non-price harms? And that may miss the boat just a little bit because I think most people agree that non-price effects matter. And I think the really thorny, difficult question is, can we develop tools that measure the non-price effects as reliably as the economic tools that we use for price effects? So very welcome focus on tools there. Now, Tammy, I want to turn to you again. What are your thoughts on the effect that the development of new economic tools may have on merger control in the coming years? Is there anything specific that you think we should keep our eyes on?
Sure. I don't think price effects is going away, but as new technologies and business models emerge and grow, antitrust laws will need to adapt to these newer models and products in those upcoming years. For example, Drew and Paul mentioned free products. In free products, we're seeing user data and privacy become treated more like commodities and as an alternative to price effects. We already are seeing those in the recent Facebook and Google complaints. Second, Paul and Drew mentioned global economy mergers. We're going to see more international enforcement, and different regulators in different countries may not they may disagree on merger remedies and whether to block a merger, like we saw in Sabre Fairlogics and in Visa Plaid, which we'll talk about in a moment. Big tech is also becoming more powerful, and as more companies kind of become trillion-dollar companies, it'll be easier and cheaper for these companies to buy up nascent competitors. So I think we will be seeing more nascent competitors mergers, and as a result, we'll see that reduction in innovation as a more common theory of competitive harm. I don't think that regulators are going to test out these theories just once or twice because they're already bringing up these theories kind of in court over and again. The feds, the states in the US, and international regulators, in particular the UK Competition Authority. So I think these theories of harm will get tested until they get some traction in courts. I think it's a matter of time.
Certainly the non-price effects are getting more and more attention in recent cases. Well, let's turn back to Paul and Drew.
Drew, let me ask, beyond tech, what are the other industries, or what is one industry where we can see increased enforcement in the coming year?
I'm glad you asked that, Paul. We've definitely seen heightened interest and enforcement activity by the U.S. antitrust agencies during the past year in financial services and fintech. And I think that we can certainly expect that to continue. I think the most notable recent example is DOJ's challenge of the Visa Plaid transaction, which involves both fintech and a nascent competitor. So as a quick recap, DOJ alleges that Visa, which has a dominant position in debit card networks, acquired a nascent competitor called Plaid based on the perceived threat of future competition. And essentially what Plaid does is it has developed a way to make financial transactions without the Visa network and connect bank accounts in an innovative new way. So my view is that we're going to continue to see increased enforcement in this area for several reasons. First off, the pace of tech innovation in the financial service area is really kind of exploding. And you have a lot of, entrepreneurial, scrappy companies looking for innovative new ways to accomplish many of the things that have been done the same way in financial services for a long time, and potentially do so at a cheaper price and in a way that's easier for consumers. And I don't see that, abating. The second reason is generally, there's just this focus on tech that is really intense right now, and you're to describe it. And I think fintech is, subsumed within that. And then the third and final reason is the relatively recent reorganization at DOJ that created the financial services, fintech, and banking section to focus on these issues specifically. Well, Paul, wrapping up, looking forward, are there any other topics that you expect will receive increased attention in the year to come? And do you have any concluding thoughts?
Yeah, Drew. Again, I think there's a long list of issues, and it's an exciting time in M&A. To name a few, I think going hand in hand with what I said before, I think there's a newfound attention on non-horizontal issues, and maybe even a recognition that those are, I guess, more important subjects when we get into these global economy mergers that are fast moving, where there's innovation, where there's zero price products. And so obviously we had the vertical merger guidelines come out this year in the US, but we also see attention on non-horizontal issues outside the US, maybe even more so. And I think we're in for an interesting ride in the coming year with regard to those sorts of mergers. Coordinated effects is another one. I think we saw some activity in coordinated effects theories. Maybe we'll see more in the coming year. And last, I'll highlight, there's continued debate about jurisdictional issues. I think Saber Fair Logics is, again, another good example, but there's plenty of debate also with regard to Brexit, and just in regimes around the world about what's a reportable transaction and what isn't, and where jurisdiction applies, particularly as boundaries blur and we move into, again, the global economy. So clearly a consistent theme there, but lots of issues to watch. It's going to be an exciting time in 2021.
Great summary by Paul and Drew, and we are grateful to them for helping us out with this program. Now, Alicia, turning back to you, Paul mentioned non-horizontal issues, coordinated effects, and jurisdictional issues as three things to look out for 2021. Is there anything you would add to the list of merger issues that you think will get prominent attention next year?
Well, I think throughout their comments, Drew and Paul identified plenty of issues, and I think that there are going to be a lot of them, including the ones that they identified sort of in their final remarks. We've already been talking about the non-price effects, harm to consumer privacy interests, harm to customers or consumers' choices. How much of a selection should antitrust law be used to preserve? But one more thing, I guess, that I'm not sure anybody's mentioned is I think that politically, the pro-competitive story of the deal is more important than it's ever been to getting a deal done without having to go to court, where at least, as the parties, the government bears the initial burden of proof. But outside of court, antitrust lawyers have said it 1,000 times, parties need to watch what they say in both formal and informal communications, internally and externally, regarding what the goals of these deals are, how they will help consumers. Telling a pro-competitive story from the outset, I think, is going to be extremely important, particularly in sectors that do involve unfamiliar and new either technology or ways of doing business.
Yeah, very good comment, Alicia. It's certainly a lot of companies have a very good reason for doing these deals, and it's important to be able to communicate that reason in an easily comprehensible way. Well, that wraps up our segment on the M&A committee. And next up, we have the submission from the Economics Committee from Eddie Hasdu and Kelly Fain.
Hi, this is Eddie Hasdu, attorney at Jones Day and vice chair for the Economics Committee.
And I'm Kelly Fain, an attorney at Latham & Watkins in San Francisco and also a vice chair of the Economics Committee.
So Kelly and I thought about this topic a little bit and came up with two topics that we think are important developments in 2020 from the Economics Committee perspective. And I'll highlight those, and then Kelly will share her enlightened thoughts on where it's going in 2021. For most transaction-oriented antitrust practitioners and economists, we think the vertical merger guidelines released over the summer probably qualify as the most significant development of 2020. Much of the VMGs reflect how the agencies already analyze vertical mergers. There was a focus on the types of harm that the agencies consider when making enforcement decisions, the risk of foreclosure, potential to raise rivals' costs, access to competitively sensitive information, and the increased risk of marketplace coordination. And there was also a focus on how vertical mergers can be pro-competitive. The elimination of double marginalization features prominently throughout the VMGs and in the section on pro-competitive effects. The VMGs focus on these concepts, but they don't provide clear quantitative or other economic tests to evaluate the effects of a vertical transaction. In fact, the final version of the guidelines removed a 20% market share screen that was in the draft version, and that would have served as a bright line safe harbor. So the VMGs, while based on agency practice, leave much room for interpretation of how the FTC and DOJ will apply the principles. In particular, we think the application of the VMGs to non-traditional vertical transactions, so acquisitions of companies that are not strictly in the same distribution chain, but are rather complementary or industry-adjacent businesses, is something that's left to interpretation and something that the Economics Committee will be monitoring, has monitored this year, and will monitor into 2021.
And so we may have wrapped up the M&A committee segment, but we're still definitely in merger land here with the discussion of the vertical merger guidelines. I'm going to turn to you, Anora. Can you provide our listeners some context here? Why are these a big deal?
Yeah, sure. Sergei, thank you for the opportunity. The vertical merger guidelines are a big deal simply because it's the first official guidance update, I think, on vertical mergers since the non-horizontal merger guidelines published by the DOJ in 1984, so a long time ago. And then it's the first time that the two agencies, namely the FTC and DOJ, jointly issued vertical merger guidance. So it's a big deal because of the history of the guidance and how the two agencies joined force here. I would also provide my takeaways of the as already discussed, that the pro-competitive effects section, I think, in the guidelines compared, especially from the January 2020 draft, seem to have been expanded, and that would reflect a more explicit recognition of pro-competitive effects, namely efficiencies, which would be a counterweight, I guess, to the potential anti-competitive effects. And also note how the final guidelines become approved. seem to be along a party line vote. There are two strong FTC dissenters. And then to some, the dissents might sound even louder than the final approval of the guidance. So I think one key takeaway would be the divide would likely to continue in the future enforcement.
That's a very interesting point, Anora. And I know, as you said, the two Democratic commissioners issued dissents when the vertical guidelines were issued. And John, I'm curious what you think, given these dissents. What do you think? How do you think the guidelines will fare under the Biden administration?
Sergey, I think it's a good question, but it's early. It's really early to tell. And I think, as with most of the questions that I think we're going to be faced with as we look at the Biden administration, a big chunk of how things go are going to depend on ultimately who's chosen to be the chair of the FTC and the assistant attorney general. There's a lot of work to do on that. And as we're recording this today, there hasn't really been any indication of that. So I would say to that answer, perhaps to that question is sort of a non-answer. Stay tuned. Let's see where we are in a few months when we know more about this, and then we can probably make some more intelligent predictions.
Well, definitely something to keep an eye on in 21. Let's go back to Eddie and Kelly.
Stepping away from merger enforcement, the DOJ's investigation of large technology companies and enforcement action against Google, and relatedly the FTC's investigation and potential enforcement action against other tech companies, likely qualify as the most significant developments of 2020. A lawsuit against Google alleges that it maintains a status as quote-unquote gatekeeper to the internet through an unlawful web of exclusionary and interlocking business agreements that promote Google as the default search engine and shut out competitors. Of course, Google's search engine is free and that consumers need not pay a subscription or fee in order to utilize the search functionality. This is referred to as a, quote, zero price market, and how traditional antitrust tools will be applied to analyze zero price markets figures to be at the center of the litigation and something that the Economics Committee will monitor into 2021.
So as we look forward to 2021, just as the vertical merger guidelines were the product of kind of significant thought about how to give guidance to parties as they think about vertical mergers, especially in kind of evolving industries. We think, and when we look at 2021, if you look back at 2020, it was kind of the year of investigations, especially in the tech sector and also into mergers more generally of all sizes. So we're looking forward to 2021 being the year of the resolution, or at least the output of many of those investigations. We're looking forward to seeing whether there's new legislation, new guidance, new rules, and of course, whether there's any interesting litigation to keep an eye on. And of course, because we're the Economics Committee, we are super interested in exactly how economic theory and economic analysis and econometrics will factor in across all those. So we are really excited about 2021. We're excited about all the things that the Economics Committee will be able to bring to the section to help inform and further the discussion on any of these points, whether it's the vertical merger guidelines, tech, or anything else. So thank you so much for your interest in the section and in the committee. And if you would like to learn more about our committee, you can follow us on Connect or Twitter or on LinkedIn, or just reach out.
Well, I certainly agree with Kelly. There are a lot of interesting things to look for in 2021. One thing that we do not have to look forward to in 2021 is the resolution, or at least a final decision in the federal Google case. The parties recently agreed to a schedule that set the trial date for September 2023. So it looks like we'll be able to talk about the Google case on a few of our future year-end specials. Though, who knows, cases do settle sometimes as well. So stay tuned. That wraps up the Economics Committee summary. And finally, today, we have the Insurance and Financial Services Committee as well. And so let's turn it over to Debbie Salzberger of the Insurance and Financial Services Committee.
The first part of 2020, although eventful in many ways, was fairly sleepy from an antitrust and insurance or financial services perspective. There were a spate of mergers in this space, including such high-profile transactions as London Stock Exchange Refinitiv, Ameritrade's acquisition of Schwab, the Aon Willis Towers Watson proposed merger, and MasterCard FinCity, to name just a few. In spite of their size and profile, regulators were seemingly more preoccupied with developing policy responses to the financial impact of the pandemic in efforts to control market volatility and other financial risks. However, enforcement activity heated up in the fall of this year, with a few interesting developments to watch. In September 2020, Deputy Assistant Attorney General Michael Murray announced that in recognition of new challenges and the, quote, massive transformation that the financial services industry is currently undergoing, the Antitrust Division is planning to lean in to antitrust enforcement in fintech, financial markets, and banking sectors. In the same remarks, Murray outlined a plan for achieving this goal, which includes the division's new partnership with the SEC and the creation of a new section within the division titled Financial Services, FinTech, and Banking. This section consolidates responsibility for banking, financial services, credit cards, and debit cards. Also, in September of 2020, the DOJ indicated that it is currently considering whether to revise the 1995 Bank Merger Competitive Review Guidelines or possibly revoke them entirely and rely only on the 2010 Horizontal Merger Guidelines to evaluate banking mergers. Revised bank merger guidelines could update DOJ's approach to analyzing product and geographic markets, specify how DOJ will incorporate online banks into its analysis, and explain whether differences between rural and urban markets will be considered. These types of enforcement activities and policy developments will stretch past 2020 and make for some very interesting trends to watch in 2021.
Well, a great summary there from Debbie. And one thing Debbie mentioned I want to go back to is that DOJ is reassessing the Bank Merger Competitive Review Guidelines. Now, Christina, I understand you have a lot of expertise in banking mergers and finance antitrust in general. So I wanted to get your take on these issues.
Sure. Thanks, Sergei. So I guess for some background, as many may know, bank mergers specifically, separate apart from fintech or financial services generally, are reviewed by numerous agencies, including the Federal Reserve Board, the OCC, the FDIC, all in addition to the DOJ. And bank mergers are unique in that they don't fall within the traditional purview of the HSR Act. And so they've always been a bit of their own animal, as evidenced by the fact that they have their own distinct merger guidelines. As Debbie highlights, and as the DOJ has long acknowledged, much has changed in the financial services and banking sector since 1995. And I think most welcome an update to the 1995 banking guidelines, which I think, quite frankly, have diverged from agency practice, both at the DOJ and at the Fed. So on the one hand, we're increasingly aware and sensitive to the importance of financial services and banks to our economy's well-being. And at the same time, it's been an area of immense innovation, as indicated by DOJ's recent cases in this area focused on nascent competition, that I think have expanded both the product and geographic markets in a way that are not presently accounted for in the banking guidelines. So I think it will be interesting to see how the DOJ and the other regulating agencies, I think we all sort of recognize the importance of interagency guidance to address these issues. And one constant theme I've heard throughout this episode, is the challenge of how to address and analyze market characteristics and effects that are difficult to quantify. So I heard people talking about, price and non-price effects and how do we quantify that. Nascent competition is historically very difficult to prove. And bank mergers are not immune to this challenge. So while there's a ton of data in bank mergers across the various regulatory bodies that are collecting data from banks on a regular basis, there are also inherent limitations to those data. And I think one challenge in the guideline revisions will be how to make guidance both meaningful and concrete for parties, which is always a challenge, while accounting for these other sort of difficult to quantify characteristics and effects that we'd like to capture.
Yeah, very interesting, Christina. Certainly seems like a lot of areas of antitrust that get reevaluated or reexamined, and I guess banking mergers are no exception. So this wraps up the three segments we're going to cover this week, and I just want to throw it open to the team, for our final thoughts. How do we make sense of all of this?
Sergei, it's interesting to see, and we're going to have two more of these where we talk about this. But this episode is focused largely on mergers. Interesting as we went into 2020, I don't know what we thought because my mind is lost. But once the pandemic hit, I think we all thought that merger activity on the antitrust space was just going to die. And I think what this summary shows us is really, despite the challenges that the pandemic had for us in 2020, we have seen a lot of antitrust enforcement in the merger space.
The agencies have been as active as ever. Interesting, a lot of commentators seem to say the agencies have not been doing enough to challenge mergers. But if you just look at the number of big cases out there, agencies have been very, very busy.
And if I would just make perhaps a plug for our upcoming episodes, this year has been incredibly also active, not surprisingly, for consumer protection and data privacy. And those topics will be covered quite extensively in our upcoming episodes.
Well, with that, let's close this one out. Part 1 of 3. So keep listening. We have and thank you for listening to Our Curious Amalgam, and we will see you next time with Part 2 of our year in review.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.